EIER or from the advocates, you feel free to ask.
Hello, I'm Maria and I'm employer, and my concern is the identity. One of the problems which a lot of you doesn't know, when it comes to change of employer, be careful of the job you are choosing. Like for example, a cab driver, all above you who have even the tag and the Maltese license cannot change of an employer when you are not a driver. So you have to be a driver to change of employer as a driver. If you work in a hotel and you want to be a cab driver, don't do it because you get refused 100%. Another thing is, if you want to do a part-time, I'm talking about cab drivers because I own cabs. If you want to do a part-time and you work, like for example, even as a driver with a bus, and you want to do a part-time with a cab, you cannot as a third world country. They don't allow you. You will pay 120 for nothing. So you have to be careful about these things. And I'm worried a lot about the identity, what is happening right now. That they're issuing the blue paper, they leave it for such long time, and then they will take the time past and the identity will not, then they will be refused. So these things, please, you can help these people, because as an employer I'm facing these problems, and I like to employ Indians and all the third world countries, and I cannot. I'm working myself, maybe cab drivers have seen me on the road. I have cars in the garage, and I cannot employ people because they're making it so difficult, this identity. We have to put our feet down. I fought many times with identity. I even shouted in their offices, okay, but my voice is nothing. Someone who has the power has to face these people. So please, this is my concern. I would like to help all of you, but we have to do something about it. Thank you.
Wants to ask questions or share any experience?
My name is Harpreet, and my question is for the lawyer that the immigration. It's not about experience. It's about that if we are going to change of employer, and we did our termination before a month before. So if he is not giving us the termination, then what would be the situation and how we can speak to our ex-employer and to the present employer?
Okay, this is a very, very important question. If you are doing a change of employer, and first and foremost, the period to start the application, you can start 90 days before your current work permit is expired. But if your employer, if your current employer refuses to give you determination, speak to Jobs Plus. You will speak to Jobs Plus, even if you ask your prospective employer to speak to Jobs Plus, and then Jobs Plus will authorize your change of employer, and then they will issue determination themselves. They will ask you, they will provide you with the documentation required, and you will fill it up, they will process it, and they will issue it themselves. So don't be afraid. Your prospective employer, if he is a Maltese or even a foreigner, don't worry, approach Jobs Plus, and they will take care of it. On the portal of Identita, when you change the employer or when you submit a new application, there is 3 dots at the end. If you're going to make a change of employer, you have either you choose that your termination has been in hand, or the employer is refusing to give, or you are still in employment. The line of chronologically, it will be still in employment, having the termination in hand, or the employer refusing to give. So you have the opportunity to choose one of these 3, and if your employer is refusing, don't be afraid, just just click the third one. Employer is refusing to give the termination letter. In the meantime, speak to Jobs Plus and then they will handle the situation themselves.
Thank you, sir.
Anyone else?
Hello, good evening. My name is Jinesh. First of all, thanks a lot to DIR team, Dr. Asupadi, Mr. Sultana for the wonderful interaction that you had. My queries regarding the equality of equal pay parity. So how do we address this? Let us say there's an employer who discriminates based on the nationality between the wage, and wages need not be financial. Let us say there is employee A and employee B, and employee A gets, let us say, additional stocks, whereas employee B in the same category doesn't get the additional stocks. So how do we take it up? How do we challenge this? I know that even European Commission is pushing for wage transparency and all, but how do we address it on a forum?
So when it comes to wages, of course, as my colleague mentioned, if you are doing the same job, you have to get the same wage. Now, if, for example, I started 2 years prior to my colleague, the basic wage has to be the same, but the employer can give an allowance for the length of service. So as long as the basic pay is the same, there are no issues under our law. As you mentioned, next year, through an EU directive, we will be obliged to rectify the pay transparency, which will help, of course, to avoid such scenarios. Until now, what you can do, we cannot claim stocks or whatever it is. Had it been basic wage, we would have claimed it. But stocks and so on, you have to file a case through your private lawyer, not through the IER.
Thank you.
Everyone, thank you so much once again. My doubt is there are so many people around here who apply for change of employer, but it's during the end of the stage that Identita comes back and says that it's been refused because it does not qualify for a TCN is not applicable for the specific job, and an EU or a Maltese is required for such, and Jobs Plus does not see the requirement for a TCN to be employed for that specific designation. So how is there any sources, are there any sources where we can see that whether this position is applicable for a TCN or not?
So basically, this question is related to the labor market test. The issue of the labor market test, there is no information on the Jobs Plus website. So basically, neither the TCN nor the EU, neither the Maltese will know what is the need in the labor market. So far, there is no information. If you encounter in this situation and your permit, your single work permit application is refused, it is very important that within 3 working days, you will file your appeal. In my opinion, I would seek immediately the advice of a legal advisor and let the legal advisor write your appeal. Why? Because there is the current practice is that you will go to the offices of the Immigration Appeals Board in Valletta. They will give you the information sheet. You will provide also the refusal letter in original, not on the phone. You have to print it and give it to them in hard copies. And you think that you have submitted your appeal. They will give you an acknowledgement receipt. That they will tell you that you are within 1 month from the date that you have submitted, you have to file the additional documents. But you are failing to submit your legal grounds on which you are appealing. And what are your demands? And here, where is the catch? That if you do not file what are your grounds and your grievances on which basis the board is going to decide whether you are right or wrong. That's why it is very important to seek a legal advice. So the legal advisor will put down the legal arguments in favor of to justify why you should not be refused. There are instances also where you will be issued with an interim permit, which we all know, it is known the blue paper, okay? You will be issued with the authority to work, temporary work, and then your application is refused afterwards. So, in my opinion, if you are in this situation where you are given an interim permit, you will have this sticker which tells you temporary authorized to work until a decision on your application is taken, and you are being refused. You will appeal, and I would say that you can still continue your employment. Why? Because a final decision is not yet taken. Because the final decision is being taken by the board and not by Identità. So, if you are encountering this situation, make sure that within 3 working days, if you receive, for example, the refusal letter on a Saturday or on a Sunday, the first working day will start on Monday. So don't panic. So if you receive it on a Friday, your first working day will still start on Monday, because Saturday and Sunday, public holidays during the week, does not count. So it is very important. Okay, I think I answered your question.
During the appeal, can they work normally?
If they have the interim permit which states that they are authorized to work until a decision is taken, the final decision is taken by the board. So a decision on the application is not yet. So I would argue, in my humble opinion, I would say yes, they can still do it.
Good evening, everyone. Thank you for the invite. My question is regarding the definite contract part. So we all know that a definite contract will have an end date, and in my case it was 3 years. So upon the expiry of that 3 year, the employer decided to extend it for another 3 years. When we all know that after the first 4 years of definite contract, it will be automatically converted to an indefinite one, but still the law says that if there is a proper justification that the employer cannot continue it as an indefinite, it is still possible to have a definite contract. My query is, after the first 4 years of definite contract, even though the contract is for another 3 years of definite, is both the parties are obliged to pay back when there is a breach of contract happens. For example, if I decide to quit, am I still eligible and entitled to pay back for the remaining period of the contract to the employee?
So if there was a justified reason for you to have another contract following the 4 years of definite, then yes, since you signed the contract, you are obliged to follow the obligations of a definite contract. So if you decide to terminate your employment, yes, you have to pay half of the remaining wages to your employer.
Thank you so much, madam.
Hi, good evening. Actually, my question is, I'm a cab driver here in Malta, and I got rejected by the Identità on
आपका
24
नाम क्या है?
July.
नाम क्या है?
Gurjeet Singh. And I got rejected by the Identità on 24 July 2024. And till now, I'm at home, I'm not working, because my application is still submitted. When I got rejected, we were more than 100 people in the same company, and some of decided to change of employer, but some decided we will stay with the same company. And I'm one of them. I'm decided to stay with the same company. But after 5 months, I got nothing, no review, nothing. So I decided to change my application to put in another company. In 4 of December 2024, I changed the company and I put my new application. So after that, Identità make my status illegal in Malta. So I go to the lawyer. My lawyer sent an email to immigration office and to make my status legal in Malta, but I'm on appeal. So they are not making my status legal in Malta. So they are telling me to its own Dentita. If they want, they can give me the ID card. If they want, they cannot. So what I do now?
So, in my opinion, you are a little bit in an awkward position. And I tell you why. Because your appeal was based on an application which you are going to work with company A. During the course of your appeal, you opt to change your employer, which you have the right to do so. However, the legal grounds on your appeal does no longer exist, because you are no longer going to work with company A, but you are going to work with company B. Even though there is a jurisprudence, there is court judgment which says that you have the right to do it, okay? It is better if you will speak to your lawyer, discuss it with him, and then it will be a discussion with him and the Immigration Appeals Board to come to reach with a decision or maybe an agreement with the Dentita, I cannot tell you, in order to solve this situation, because you are a little bit in an awkward position, because your appeal was based to work with company A, and in the meantime you changed to company B. So if your application with company B is still submitted, then your lawyer has to speak to Dentita, and you will come sort of with a solution, or Dentita issue the solution, which I have no doubts, but I have a little bit my doubts about it, but it is better if you seek it personally with your lawyer.
Anybody else? पहले आपका नाम, then question.
Hi, I'm Christina. I wanted to ask a question, as per my definite contract as a live-in carer, is there if it's a 1 year definite contract, is it 6 months, 6 weeks of probation period? I mean, is that, correct? If it's a 1 year contract, 6 weeks of probation period, because I think you said 6 months.
So 6 months, it's for an indefinite contract. If you have a contract of 1 year, it has to be proportionate to the probation. So what I said was that if it is for 1 year, normally the probation is 3 months. If it is for 2 years, then it's 6 months.
Even for a live-in carer?
Yes.
So it cannot be 6 weeks. So 6 weeks would be wrong.
So for probation, unless agreed otherwise by both parties. So if you have 3 months, but both yourself and the employer agree to have 2 months or 6 weeks, even 1 day of probation, then the law allows it.
I have another question. Even change of profession, if you're an MQF level 7 and then you end up doing MQF level 3, would that be a problem? And then you shift from one employee, from one employer to another employer. In terms of healthcare, would it be a problem legally?
Unfortunately, I cannot reply because it is not something regulated by our department, MQF levels and so on. For probation, however, what I've said, if we have a definite contract of 1 year, it has to be proportionate, 3 months. If you agree for a lesser period, both parties can proceed.
My name is Sana and I work as a marketing coordinator. I have an indefinite contract, and in my contract it states that I have a performance bonus for X amount throughout the year. Now, if the year has passed on and I have still haven't received my performance bonus, is there some legal way I can go on about, or how is the process? To be honest, I have no idea.
So performance bonuses are not regulated by the IR, so we cannot claim it. Had it been basic wages, notice and so on, we can claim it. However, in that case, you have to seek the assistance of a legal advisor, a lawyer, and if you wish to do so, you can of course initiate legal proceedings against the employer.
But it's legal to do it.
If it is
Because it's
stipulated.
stated in the contract,
Exactly.
so I can go to a lawyer and
And
claim
you-
and go on about the process.
It is binding. What is written in the contract is binding.
All right. Thank you very much.
Anybody else there?
Myself, Mahesh. So I'll be someone's voice today. He's not here. So the case is the person is working for one of the consultancy. The payslips is getting by the same consultancy. So his designation is laborer, and he was working as a machine operator in one of the company, like client's location, till February 28. And then he finished his job on that side, on that location. Then the consultancy forced him to work as a housekeeper. Like they forced him to send him, so he refused to work. So then it passed, like 15 days have been passed in March. Then on 26th March, he got the termination letter with the backdated like February 28. And on October 12th, he got the revocation letter from ID Monitor. In that case, since it's already 15 days has been passed from the last termination date, so what kind of actions he can take on the company with the help of DIRE or lawyers? Because this is a common practice which is happening, like a backdated terminations from the consultancies or companies.
Can you please repeat a bit the time frames?
Hello? So he is a laborer. So in the client A, he is working as a machine operator, and in the client's location he finished his job. So the consultancy guys told him to work as a housekeeper with another client.
Okay.
Then he refused, and he tried to negotiate it with them, and they told him, like the client, the candidate also told the consultancy to terminate his position so that he can find another job. And by March 26th, he got the termination from the Jobs Plus with the backdated February 28th.
Of this year?
Yes.
Yes, okay.
And on April 12th, he got the revocation letter from the ID Monitor.
What is the date?
April 12th.
April 12th. He got the revocation.
Yes.
So, in my opinion, he should seek a legal advice and try to challenge the. If he has any documentation to prove that he was still in employment until April, he can provide everything to the National Employment Authority, and he will ask them to correct the termination letter.
Last
Because-
pay slip was in February itself. Although the pay slips are coming from the consultancy, they have a mutual chats between the consultancy and this guy till mid of March.
So, am I correct to understand that this guy is working with a temping agent?
Kind of, yes.
So, the temping agent is responsible.
Correct.
So, if the temping agent has terminated his employment backdated,
Correct.
there are rules and regulations which regulate temping agents, which I believe the IR can go into it. But if he would like to correct the termination letter, he will engage immediately without any further delay, okay, to the with a legal advisor, and he will challenge that termination before the National Employment Authority, and he will provide all the evidence, including chats and everything that he has.
He already tried negotiating with them to change the backdated termination with date.
It's not going to work, sir.
Yeah, when they said the same thing. So, but
He needs
although
to challenge it before the National Employment Authority,
okay,
because they are the body that has the authority to correct the termination letter.
so they can seek the DIRE still assistance.
With regards, because it's involved a temping agent.
Thank you.
Thank you, Advocate Sultana. Now we are running out of time, so unfortunately this time we will not be able to take more questions. May I request Her Excellency Madam High Commissioner to please come forward and thank our esteemed speakers. I would like to invite Miss Mary Grace.